Good morning, friends. I am again before you with important case law, leading case law, which is in the syllabus of Advocate on Record examination, likely to be held in June 2025. The title of the case law is MC Ujjain versus BVG India Limited 2018. Friends, this is important decision by the Honorable Supreme Court of India regarding enforceability of arbitration clauses in contracts, especially when the contract has been executed under public procurement law. The issue before the court was whether the arbitration clause in a public contract was enforceable or if such disputes should be resolved through judicial courts under the applicable public procurement law. So, before proceeding further, let us dive into the facts of the case. This case revolves around a contract for public services between MC Ujjain, Municipal Corporation Ujjain, and BVG India Limited, a private company. BVG India Limited private company was awarded contract by providing certain services relating to cleanliness and waste management of Ujjain. The contract contained an arbitration clause which provided for the resolution of dispute through arbitration. And the dispute arose between the parties, and BVG India Limited invoked the arbitration clause to settle the matter. However, the Municipal Corporation of Ujjain argued that arbitration clause was not enforceable because it was part of contract executed under the Public Procurement Government Contracts Act, and such contracts should not be subjected to arbitration clause under private laws. So this was the facts of the case. Then Honorable Supreme Court gave its observation and then the judgment. The court observed that arbitration clause in a public contract is enforceable, even though the contract is governed by public procurement law. The public procurement law does not bar arbitration in contracts executed by public authorities. Further, the court emphasized that arbitration, being an alternative dispute resolution mechanism, can be utilized in cases involving public sector undertakings and government contracts so long as the clauses are not contrary to statutory provisions. Then, Honorable Supreme Court made it clear that public procurement law, which typically aims at ensuring transparency, fairness, and competition, should not be seen as an absolute bar to arbitration. It was held by the Honorable Supreme Court that arbitration could be valid as long as it does not contravene any specific statutory provision or the public interest involved. The court further clarified that while arbitration is encouraged for its efficiency, the enforcement of arbitration clauses in public contracts must ensure that they comply with public policy and legal framework governing such contracts. So, in this case, since the arbitration clause does not conflict with the any public procurement statute, so it was upheld to be valid. So, Honorable Supreme Court gave its judgment and held that arbitration clause in public procurement contracts are enforceable provided they do not violate statutory provisions. The court allowed the arbitration process to proceed and emphasized the need to respect the contractual agreements made between parties, including the arbitration clause. So, The significance of the judgment is this judgment promotes the use of arbitration as an alternative dispute resolution in government contracts, thereby reducing the burden of regular courts. It further clarified the status of arbitration clause in public contracts, ensuring that such clauses are not rendered unenforceable merely because the contract is a public procurement contract. This ruling reinforced the legitimacy of arbitration in government and public sector undertaking, promoting a faster and more efficient resolution of disputes. Now, after the judgment, there was criticism too. Some critics argued that arbitration in public contracts, especially in the context of government tenders, might lead to lack of transparency if the process is not regulated carefully. And others have raised concerns about the potential lack of public scrutiny in arbitration involving government contracts. Nutshell, concluding by this video, MC Ujjain versus BVG India Limited, Honorable Supreme Court upheld the enforceability of arbitration clause in public contracts, emphasizing that such clauses do not violate public procurement laws so long as they are not conflict with statutory provisions. The judgment further reinforces the idea of arbitration as an effective and efficient alternative dispute resolution mechanism even in the public sector. So this is all about this case law, and I will go on proceeding with the videos until I go to the end of the case laws which are in the syllabus of advocate or court examination. So I feel you must be enjoying the videos, and if you feel that there should be some improvement, do feel free to call me. I will oblige you by accepting your request. God bless. See you again. Have a nice day.